absolutely fine.
Right, go for it.
I should begin with a small caveat, which is that I've just been earlier this evening at the protest against the Rwanda flights in York, and I'm now wondering if attending something that involved loud chanting was a particularly good thing to do before giving a talk. So my voice, at the risk of sounding like a precious opera singer, my voice might give out, but hopefully not. But thank you so much for inviting me to talk today. I thought probably the best thing to do would be to give a bit of a flavour of the kinds of problems that we're seeing in the context of the research project that I lead, which is called the EU Rights Brexit Hub. So it's a research project based in the University of York, based in the Baroness Hale Legal Clinic in York University. And we give second-tier advice. So we work with organisations like citizens' advice organisations, other organisations, including local authorities as well, and various NGOs and law centres who get in touch with us if they've got queries relating to EU or EEA nationals' rights, particularly when it comes to accessing public services. And we provide the expert advice, but also we kind of document the problems that we're seeing for research purposes and advice-led ethnography, but also for policy purposes. So in order to be able to respond to consultations or present evidence to various authorities that things are going wrong. So I mean, this whole project was premised on the hypothesis, things will go wrong, let's find them out, let's capture that as they're going wrong. So yeah, surprise, surprise, things haven't been as smooth as they might have been post-Brexit for EU nationals in the UK. And a little reminder, of course, that we're talking about the lives of, I mean, we don't know how many EU nationals up there are in the UK. The estimates are, you know, 3.8 million, possibly more in light of the quantity of people who've applied to the EU settlement scheme. Of those, 2.69 million estimated to be of voting age and 2.3 million estimated to be in work. And all of their rights were decided upon in one fell swoop in the referendum on the basis of 635,000 Leave voters. If that many voters had voted to remain, then this would have all gone away. And these were people who are not entitled to vote, this 3.5 million, 3.8 million people in the referendum. So I feel it's important to put that into context because it's kind of sobering that a relatively small portion of the electorate has had such a dramatic effect upon the rights of these people who are, you know, in many cases, our friends, our families, our colleagues, our neighbours, people who have been in the UK for quite some time, including children who were born in the UK as well. So they have been hung out to dry, is my argument, by a whole range of authorities since the Brexit vote. Now, in the lead up to the referendum, there were a whole bunch of, by now famous, promises coming out of the Leave camp, whether it was to do with the hundreds of millions that would go to the NHS, or whether it was the threats of being deluged with Turkish nationals. A promise that was put forward by Michael Gove, Boris Johnson, Priti Patel and Gisela Stuart on the 1st of June 2016 was that there would be no change for EU citizens resident in the UK, that they would be automatically granted indefinite leave to remain. Now, this has patently not come to pass, the idea of rights being automatic or indefinite. Instead, they were treated pretty shoddily straight away. Commentators described them as being treated like bargaining chips because there was no effort on the part of Theresa May's government to offer any immediate or unconditional guarantees as were being called upon. And yet I've argued elsewhere that actually in some ways they were being treated worse than bargaining chips because it wasn't entirely clear what the government was intending to leverage out of refusing to give those guarantees, given that the EU was already making suggestions and offers about how UK nationals would be treated in the EU. So in fact, they were just being treated more like kind of collateral, acceptable collateral damage rather than bargaining chips. And then the next failure was that of the EU negotiating team when it came to the withdrawal agreement and making proposals about who would be covered. So their proposals cleaved very closely to secondary law, a directive in EU law that gives narrow categories of people who have a right to reside in an EU member state, EU nationals in another EU member state. They have a right to reside that entitles them to equal treatment, such as access to benefits, etc. And to have that right to reside, they typically have to be in work or the family member of a worker. Now this, in normal EU law terms, is kind of coupled with some of the safety net that comes with the EU treaty background. So the people who might fall through the net of the directive may nevertheless be caught by the rights that are accorded to EU citizenship. So rights to reside and rights of equal treatment attached to people qua citizen. Now, none of this extra safety net was imported into the withdrawal agreement. It was just based on the narrow bare bones of this directive that essentially requires work or being related to a worker, which meant that all the gaps that a number of us have identified in the directive over the years were just being transplanted directly into the withdrawal agreement. So the people to be covered in the withdrawal agreement had to demonstrate that they were exercising a right to reside, not just that they'd been in the UK for a certain period of time. And this meant that there were whole swathes of people who would fall through the gaps, including children, who had no right to reside under the directive and therefore under the withdrawal agreement in their own right. Their rights are entirely parasitic upon what their parents have been doing, and so entirely dependent upon the employment, the migratory, the relationship choices and misfortunes of their parents, no personal rights. This is extremely damaging potentially if you think about the kinds of people who we might, so EU nationals born in the UK, grown up, reach the age of 16, 17, and may become estranged from their parents, would not be covered by the withdrawal agreement, would be expected to be booted out as far as the EU negotiating team is concerned. That strikes me as deeply, deeply problematic. And again, there are other people who have punctuated work histories or have reduced capacity for work as a result of care responsibilities or as a result of disability or long-term illness, who would again potentially fall through these gaps, huge gender gaps and huge children gaps in the directive and then in the withdrawal agreement. So as far as I'm concerned, the EU negotiating team really let a lot of EU citizens down there. And I helped some MEPs, members of the European Parliament, to write a letter to Michel Barnier pointing this out and asking for more of asking for a reference to EU citizenship or to proportionality, something that would recognise there'd be a fallback, there'd be something for the people who weren't covered. And the response we got was essentially, well, we're just stuck with the free movement law. We can't go beyond that, which to me brought home how little expertise there was on the negotiating team when it came to EU citizenship rights or how free movement works on the ground. So anyway, that was a big letdown. But then the UK, not to be massively outdone, also produced its own various pitfalls for EU nationals. Now, the way it implemented the withdrawal agreement is the EU settlement scheme, which on its face is more inclusive and more generous than the withdrawal agreement because it does not require someone to show that they're in work or that they've been in work. It's purely, and this is just a matter of administrative necessity, I think, the idea of actually assessing everyone's work history when you're dealing with millions and millions of applications in a short space of time just wouldn't have been possible. So matter of administrative necessity, it's just about time. Have you been in the UK for 5 years or more, with some exceptions, then you get settled status. If it's less than 5 years, then it's pre-settled status. Now, the sting in this settlement scheme tale came with deciding to make it a constitutive scheme rather than a declaratory scheme, which meant that if you did not have your status by the deadline, which was the 30th of June 2021, then you lose your entitlement. So it's not like, for instance, if you fail to renew your passport as a UK national, by the time it expires, you can at some later point nevertheless renew it or apply for a new one on the basis that you have an underlying entitlement. Here, you miss the deadline, all your underlying entitlements fall away, unless you can show that you had a reasonable ground for not applying in time by the deadline. And the longer the period of time since the deadline goes, the harder it will be to demonstrate a reasonable ground. And this is one of the reasons why a number of people have been warning about a kind of Windrush too with regard to EU nationals, that there will be people who can only realise several years down the line that they are statusless and come to try and apply and find that they're not entitled. And the fact that they may have worked for X periods of years in the past, pre-deadline, counts for nothing. So yeah, a worrying approach to adopting a constitutive scheme. And in many cases, it will be the vulnerable, people in vulnerable positions who will fall through, people who won't have registered yet, or people who've got pre-settled status and then fail to register for settled status when they become entitled to it. They may not realise that they have to, they may think it's automatic, they may not know anything about their status because they may have had considerable amounts of help with applying in the first place, and that help may no longer be available, or their care situation may have changed. So there is a whole maelstrom of problems coming down the line when it comes to the deadlines of people with pre-settled status and what happens when they haven't upgraded to settled status. And so yeah, a whole bunch of problems in terms of how the scheme was conceived, but also it's suddenly having these parallel and not identical schemes in the EUSS and the withdrawal agreement creates a bit of a disjuncture when it comes to enforcing those rights, because the EU Commission, I've been told, are taking the approach that there is a true cohort of EU nationals, i.e. those that would have been covered in the withdrawal agreement, and an extra cohort, those who are covered because of the UK's broader approach to the EUSS, but who fall outside of the scope of the withdrawal agreement. Now, it's not clear what approach the EU is going to take, or the CJU is expected to take to this true and extra cohort. Are people who have pre-settled status or settled status, but who can't show that they fall within the WA, not going to be covered by the enforcement mechanisms provided by the Independent Monitoring Authority or the European Commission or the Court of Justice of the EU? It's just not clear. It's kind of messy, to put it mildly. And there's going to be a risk of significant frictional injustice as we're moving between these different schemes. And let's not forget there's this backdrop of the entire immigration regime altering, with the rules applied to new arrivals, i.e. people who arrive after the 31st of December 2020, facing completely different rules in terms of what, when they, how long they could stay for and whether they can work. And the amount of administrative friction there is likely to be amongst decision makers trying to figure out whether someone fits into category A, an EU national with the highest amount of migrant rights, or category B, an EU national with an extremely low amount of rights, is going to be, I think, potentially quite disturbing and disruptive and distressing for the people involved. Now, the EUSS itself has been fraught with delays and is increasingly so, as we've seen, as we've got past the deadline for application. It seems, I mean, it's difficult to know from the outside, it seems as though the Home Office is committing fewer resources to it because there's been a massive slowdown in the decision-making process, even though there's still a huge backlog and an increasing backlog as people make late applications as well. And that means that delays are suddenly becoming more distant than they were. I mean, we've seen a case where a client had been waiting for 15 months for a decision. And it turned out at the end of it, she was entitled to settled status, which means, you know, the full panoply of rights and equal treatment rights. But during that 15-month period, she was not entitled to benefits and was, you know, forced into a state of potential poverty because of these knock-on effects. And what happened when her settled status was awarded, it was awarded as the date of the decision. Even though her application was based on her status 15 months prior. So there was no backdating of the status. So she just, for that period in which she should have been entitled to settled status and therefore should have been entitled to benefits, it was all just written off, not entitled to it. We've also seen a case where a client has faced huge amounts of delay in simply getting not even a status, but a certificate of application, which is kind of a receipt to show you've applied. And the fact that they haven't been given that certificate of application has had a knock-on effect on them not being able to accept job offers that have been made to them. So it's having enormous effects resounding around these people's lives, and actually problematic for, you know, with the economy if we're stopping people from working who should be. Decision maker error is another area where we see problems all the time, regardless of Brexit, but particularly in light of Brexit. A huge amount of misunderstanding of the rights of pre-settled status, including the rights of pre-settled status who are in work. So we had an advisor reach out to us who had a case where the advisor had spoken to the decision maker to query why their client had been refused benefits, even though they were in work and they had pre-settled status. And the person who spoke to them on the helpline said, oh, Brexit means that new rules apply and the old rules have changed, and so it doesn't matter that the client is working now. And that's just a fundamental misunderstanding of what the transition rules are and what rules are in place for people with pre-settled status. And so we had to go to some lengths in order to try and put this right, while also recognising that this might be a more systemic problem, that it's not just one errant advisor, that actually there may be more problems with advisors, with helpline advisors at large, or with the guidance that they're using. We have been able to make a few successful interventions in various cases where there's been, really basic misunderstandings, like with a inaccurate or inappropriate application of a minimum earnings threshold, finding that someone is in work but isn't in work enough. And we've been able to supply advisors with arguments for refuting that. And to deal with significant misrepresentations of the law. And we've got permission to raise some of these, we've got permission from the advisors, we've got permission from the clients to raise some of these with the relevant local authorities and with the independent monitoring authority to try and get a sense of how widespread some of these problems are, and to put forward the suggestion that someone might want to do something about it. Digital status is another area that's caused very significant problems, huge ramifications. So I don't know if you already know this, but the EU settlement scheme is a digital only scheme. It's been viewed as the Home Office kind of using EU nationals as a guinea pig, trialling a scheme that they would like to roll out more widely. You do not have a paper copy of your status. Your digital status is it's not even a downloadable thing. It's only on a URL that has to be accessed live in real time. And so if the website is down, or there's a problem with the internet connection, or a problem with the Home Office records, it just disappears. You can't access it. And there have been numerous cases that we've seen where people have not been able to access their status at the point that it's required, putting them in significant jeopardy. If you imagine that, in the state of facing a border official, for instance, but also having effects when people are going to apply for to rent. They need the right to demonstrate they have the right to rent, or applying for a job. And if there's a difficulty accessing that, and even if it's straightforward, theoretically straightforward, it still involves multiple steps. I think it was the Public Law Project, if you will put me right if I'm wrong, who demonstrated that this process requires something like 7 steps on the part of the employer and then 7 steps on the part of the applicant before you can actually get confirmation of status, as opposed to going, here's my passport. And so it could be that what we end up seeing is employers and landlords actually just being totally put off by this alien process that's cumbersome and that they maybe don't trust, and that puts them at risk. If they get things wrong, they could be breaking the law thanks to the hostile environment, and they'll just find it safer to rent to or employ UK nationals instead. The delays that can be caused by the digital status problem also have other effects. So we had a case with a client who was in hospital, who had made an application for benefits while in hospital, but the person on the end, the helpline advisor, didn't really understand how they were supposed to process this digital status. And so they ended up making a mistake that ended up in an automatic refusal of benefits, which resulted in this client being forced to stay in hospital because they couldn't leave, because they couldn't be rehoused, because they couldn't get benefits, all because of this digital status issue. And we've argued that there are discriminatory effects of this digital status because it impacts in particular on people who are vulnerable to technological exclusion, which could be, you know, the elderly, it could be the people with impaired capacity, but also people who are more at risk of being dislocated from a set home, so people who are homeless or people who are fleeing domestic abuse and so on. So deeply problematic. Another area that we've spotted has been confusing guidance. Decision maker guidance is the stuff that, as far as decision makers are concerned, is the bread and butter of the law. They only look at the guidance, not the law, as one specialist advisor actually told me in my last project. We don't look at the law, only the guidance, when I tried to make an argument about the law. So the guidance has to be right if it's effectively taking the place of the law, and so frequently it's not. It's being compiled at speed and being put out at speed, and there are mistakes, and some of them may not even be entirely accidental mistakes. There's definitely dodgy guidance, to use a technical legal term. So, for example, we spotted that there was an issue with a test that was being applied to people claiming retained worker status, so people who were out of work but had been working and should be allowed to keep their status. And the test was called the Genuine Prospective Work Test. And the upper tribunal had found that this test was not appropriate or lawful and should not be applied. And yet the guidance for decision makers, the main body of the guidance, told them to do it, kept on telling them to do this test that the courts had told them not to do. And when we approached DWP about this, they said, oh, but there's a memo attached to the guidance that tells them actually don't do that. But the problem with that is, if someone's read the main body of the guidance, they're not expecting a memo that actually contradicts it. So being told, oh, the memo supersedes it, not helpful, especially given that we were seeing cases in which the main body of the guidance was being relied upon. And what's more, this dodgy test that the courts had found unlawful was being used in template letters that were sent to all universal credit clients, telling them how cases were decided, included a reference to the Genuine Prospective Work Test. And so we had to go through this big back and forth. We have eventually got it changed. This tiny thing, but was affecting a lot of people. It's changed in the guidance and changed in the template letter, or at least we've been assured it's been changed in the letter. But yeah, it was arduous to get to that point. On the subject of dodgy decision maker guidance, there's now another bit that we're touching on, that we're working at, chipping away at, that again, it doesn't, it's not accidental. The DWP have been quite explicit about this. The case in the CJU that dealt with pre-settled status and access to benefits. Now, this is where I believe the Court of Justice has let down EU nationals by finding them not entitled to rely upon equal treatment provisions unless they're actually in work, and therefore not protected by EU law. And we're dealing with a pre-transition case here, so it was EU law was supposed to be applicable. But leaving aside the CJEU's failings in this case, what they did come up with was a safety net, a fallback of using the Charter of Fundamental Rights. So people with pre-settled status who need to claim benefits because otherwise there's a risk to their right to dignity or the best interests of the child, for instance, could claim benefits on that basis. Now, the DWP approach to this has been essentially to go la 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 la, and they produced some guidance that made minimal reference to CG and no reference at all to the duty under the Charter of Fundamental Rights. And when the Child Poverty Action Group approached them about this, the response was the Secretary of State does not consider this is required as a result of CG or otherwise. So they just unilaterally decided that this binding judgment actually has no purchase or meaning for them. And so we have been working on a memo to the House of Commons Work and Pensions Committee and a complaint to the Independent Monitoring Authority, the body that is supposed to uphold the withdrawal agreement, pointing out that these people are supposed to be protected by the Charter. And the UK government's position is they just don't need to because they don't really want to. So, oh yeah, on the issue of accountability, the fact that there are these monitoring bodies that are supposed to be checking that the withdrawal agreement is being enforced and that EU nationals' rights are being protected. We have, like I say, written memos, made complaints. We're still in the process of gathering evidence for a few other potential complaints, or if not exactly complaints, more sort of pointers to the IMA, things they might want to look into or data they might think is useful to gather. We've also given evidence to the London Assembly on general EUSS stuff. We've given a private briefing to the House of Commons Work and Pensions Committee. We've been invited to submit evidence to the House of Lords, the European Affairs Committee, which was then cited in the report. We've drafted parliamentary questions, 8 of which have actually been asked in the chamber. So, I mean, there's a lot that we're kind of doing, or at least trying to do, in order to address some of these problems on a policy front, on a systemic front, even though, like, you know, like making the point about the Rwanda flight at the start, it feels like being King Canute and standing against a tide where you're just being attacked on all sorts of fronts with dreadful things happening. So in a way, it feels like quite a depressing policy environment to be trying to work in. But the fact is that there are these protections that are supposed to exist for EU nationals, and so we're doing our best to help them realise that. And this legal action research is kind of an opportunity for us to get inside the problem and actually do some good. And in the process of the fact that we can get these good decisions for individual clients and for families at the same time as capturing evidence that can work on a bigger scale is, I think, really promising. And it's a, you know, it's a method that I'm trying to push with other law schools as well. And the fact that we get to work with so many other NGOs as well is fantastic. It gives us an opportunity to support higher level litigation, so we feed into cases that are going, you know, whether it's up a tribunal or to the Supreme Court or to the CJEU. And also producing resources for advisors. So one of the things that we try to do, as well as doing the individual stuff on a case-by-case basis, is find out, well, actually what they'd really like some help on is this issue. Lots of people are asking about it. We can produce like a fact sheet about it or a template skeleton argument. So the whole idea is that we can do our best in our own small way to try and support advisors to keep on trying supporting EU nationals, and we can adopt or remember to adopt the 2 V's, to regardless of what's going on, to be vigilant and to be vocal, because protecting and guarding the rights of EU nationals in the UK who are, as I say, people who've been living with us as our friends, as our colleagues, as our neighbours, as members of the community, as members of the society, deserve our support. Thank you.
Wow.
Wow, Charlotte, that was amazing. I was just thinking at that time, I wish you'd been one of my lecturers at university. I would have found it all a lot easier, but I had some good ones anyway. Thank you. That was so succinct. It was horrifying, but succinct. And thank you very much. And I promise you that will get posted, and we will share your wisdom. Have you got, are you all right for another half an hour to take some questions?
Yes.
You're
yes.
fine. I'll promise you, you know, it won't go on longer than that. Okay, so folks, can we know we've done it before. If you can raise hands digitally, if you do have questions, perhaps, perhaps we could do it by keeping them reasonably short and general at this stage. Anyway, I think there's fairness. We don't want to talk about people we know. I think one thing, I'll just preface everything and ask Charlotte, if in the course of our campaign and our working and our friends, with which we've got a number of Europeans, the sort of folk you're describing, where can, put it bluntly, where can we point people to for some more informed help than I'd be able to offer them? Charlotte.
Yeah, so like I say, we are second tier on the grounds that it allows us to capture evidence from a sort of a wider area. We can work with organisations around the country, and we get quite a lot of queries from Northern Ireland. But so when individuals approach us, we tend to, you know, we've got some basic bits of information that we can share, but usually what we do is we signpost and say, and if you get in touch with them, then you know, they're very, very welcome to get in touch with us. But the main places where we send people will be citizens' advice or a law centre if someone's lucky enough to live close to one.
Yes, I mean, are there many lawyers practicing in the York region with the necessary level of expertise? You don't need to name them, but just so give an idea.
Well, what I would say is they don't need to be in the York region. That there's a few really good lawyers who do remote support for EU nationals, particularly when it comes to the EUSS. So there's the Free Movement website, which is run by Colin Yeo. People can access support through that website. And I'm just trying to remember the name of the other organisation. I'm sure it will come to me. But yeah, there are other lawyers. It's also worth looking, if it's someone asking specifically about the EUSS, checking the Home Office has a list of organisations that have been funded to offer specialist support on EUSS, particularly to vulnerable claimants.
Wow, that's interesting. Thank you very much. Any hands raised for questions, please? Come on, somebody.
I'll do that.
Martin.
No, gosh, it's only because I've got so many, Charlotte, not that I haven't got any. It strikes me that one of the potential obstacles in a system like this is you have the government set up in departments, many of whom need to be involved to resolve a particular legal issue, and they're not talking to each other, or they're not even recognizing the problem. Is that something you're encountering? And do they show any signs of wanting to sort of get a central force at work to try and communicate between the areas of the government?
No, I mean, that's a really interesting question. The first project that I did before this one was a pre-Brexit project, working with EU nationals accessing benefits in the UK. And one of the key findings was that claimants struggled to put things right when they went wrong because of communication problems between departments. And that was particularly on a sort of a granular level, dealing with things like in the income support decision maker would want a particular bit of evidence, but they'd require them to submit it to Job Centre Plus. But Job Centre Plus were expected to then send it to the EU caseworking team, who were then based in Wick, but they couldn't fax it, and they couldn't email it, and they couldn't pick up the phone to them because they didn't know their phone number, and they weren't even allowed to use the normal post. It had to be this special internal post that was 3 times as slow and less reliable. And then by the time, whether or not they got it was a matter of chance, and if they did, then they'd communicate back through Job Centre Plus, who then eventually communicate back to the original decision maker. Now, what we're encountering in this project is less of that stuff, because mostly what we're dealing with is the issue of prima facie eligibility, the difficulty in establishing whether or not someone can apply for something, because whether or not they've got settled status or pre-settled status, or whether or not they've got a certificate of application, for instance. So, so there are similar problems, but they're just kind of relocated to include the Home Office more and DWP less.
Right. Okay. Yeah, I see. So, all right. But sorting out the settled status issue is just a prelude to a whole load of other hassle, isn't it? From what I understand. So you might sort that out at the front end, but then you're immediately walking into another minefield of communication complexity, potentially. Yeah, okay.
Well, I mean, especially with the digital status stuff, the fact that it is so poorly understood by some people who are making, really key and important decisions. And bear in mind that while some basic problems may be put right down the line, you may be dealing with people who refuse something and then they don't know that they should appeal it or that they can appeal it. And so there will be, a natural kind of attrition of people just basically being disentitled from stuff from which they ought to have been entitled. The old adage that justice delayed is justice denied.
Yeah. Okay. Yeah. Right. Okay. I'll let someone else have a go.
Is there anybody else? Your questions were very. Any hands?
Go.
Go on, Martin. You're on a roll because it's very useful.
Well, it's sort of you might have touched on it indirectly, Charlotte, and I missed it. But I wanted to ask you, what is the potential? I mean, well, I'll take a step back. As an EU citizen pre-Brexit, your right to live here was absolutely guaranteed by virtue of you being a European citizen. It seems to me that what is happening for all Europeans who stay is, even though there's settled status, it's still a very secondary level of a right. You're not a full-blown citizen of this country, and your status can be reversed for a whole raft of reasons, some of which I know about and some of which I don't. Could you say a little bit about what are the circumstances in which people will could suddenly find themselves ejected on the grounds that they're no longer on the team under the rules?
No, it's a slightly tricky one, because the rules on removal from the UK are, again, transplanted from the directive. So they're very similar to what they were before.
Yeah.
But there's a whole host of other problems that come with demonstrating that you meet the criteria for A, B, or C, rights to protection, because the rights to protection increase with the period of residence. I'm just trying to think of ways of demonstrating that it's a secondary status. And I mean, the main way of demonstrating that is the severe cliff edge that you face if there is a problem in accessing your status. So you can have settled status, and that entitles you to a great number of things, but if it's digital, and if, shock horror, something goes wrong with the Home Office records and someone deletes it, what recourse do you have? What's going to happen? Or if there's a problem accessing it at a crucial point in time, what's going to happen? So there's always going to be a certain amount of precipice involved in someone relying upon their digital status. And as far as people with pre-settled status are concerned, that that's very much a tertiary status, because the approach is, well, you're not entitled to equal treatment on the basis of pre-settled status. You have to show that you're doing other worthy things in order to be entitled to access benefits and so on. But I'm gonna think about the removals question.
Okay.
I'll give you a break of voice, something I'd like to know myself. I mean, I think one of the reasons we're getting, certainly personally, we're getting few questions is you've suddenly taken the scales off our eyes to a whole area of expertise and inequality and persecution that, frankly, I just wasn't aware of. I mean, but bar the surface, what are bodies, legal bodies or political bodies on the continent thinking about nefarious Albion at this point?
Oh, I guess you'd have to ask them. It's worth noting that the majority of EU member states, everyone had the choice under the withdrawal agreement whether to adopt a constitutive scheme like the one in the UK that kicks people out effectively or subjects them to the hostile environment if they haven't got status in time, or a declaratory status, which was the same as it was before, basically, that you might not have applied, but if you can demonstrate that you basically meet the conditions, you're entitled. And the majority of EU member states went with declaratory, with continuing the declaratory status. Like I say, there's much less risk of a cliff edge situation developing there, much less risk of a kind of a windrush down the line for them. As far as the issues relating to administrative difficulty, I'm not entirely, there's a number of projects who are working on the rights of rights of UK nationals in the EU, the Brexpats project, who are, I think, working on in different member states and capturing that kind of data. I don't know how comparable it is to what we're seeing here. But I mean, it's worth noting that the Court of Justice judgment, of course, is not just a judgment that pertains to the UK, it pertains to the whole of the EU. So they have potentially undermined the rights not only of EU nationals in the UK, but of UK nationals in the EU and of other EU nationals in other EU countries. So yeah, it's kind of, I'm not convinced that there's anyone who's got a really strong moral high ground on this.
Thank you.
Okay. So,
anyone else got any other questions? Come back to you, if you want, Martin. we've got a few more minutes.
Yeah. No, we make it clear, Charlotte, that the EU is not entirely blameless in this situation, and appears to have hung their own citizens out to dry a little bit. So, is there a connection between EU citizens in the UK making some kind of appeal to the EU to reconcile the legal disparities where they exist? Is that happening at all, or is that just kind of dribbling along?
Sorry, I don't think I quite understood the question.
Okay, right. Possibly because I don't understand it myself. As I understood it, you were saying that the EU have taken a view that we can't do anything but operate within the guidelines that would apply to EU citizens in any other country. That's the limit of our remit. And you are saying, but that in itself does create a problems, because there's an incompatibility in some respects between what we have included in withdrawal agreements and what the EU are using as their reference point. So what I'm saying is the body of EU citizens living in the UK making any representation to the EU about the issues that develop and saying, can you do something to align these things and not just say, sorry, you can't help? Does that make any sense?
Yeah, so is the IMA making representations to the EU? And yeah. I don't know what they're doing. Okay. Is the answer. They have published a kind of a list of some of the issues that have been reported to them that they're investigating. But in terms of what their relationship is with their EU counterparts, I'm not entirely sure.
Okay.
And I've not seen much evidence of dialogue, cross-border dialogue, which I think there probably does need to be more of. Given that the IMA does seem to take quite a different approach to the way the European Commission works, and the IMA is meant to be a mirror organisation, if you like, to the European Commission. So yeah, it's a developing issue, and the question of accountability and scrutiny as far as the IMA is concerned, I think is a really sort of interesting area, because it's such a new organisation. There hasn't been anything quite like it in UK regulatory bodies before, and it has actually potentially quite strong powers compared to other domestic regulators. But you know, my concern is that it'll end up being quite timid about whether or not to use them.
Right. Okay.
Just to say that Sheila has just put up a note to say that Richard Corbett, who's ex-MEP and old friend of York for Europe, he helps people who approach him. He still does work to help in this arena as well. I know he's certainly a Facebook friend of ours, and there are other ways. He's got a website, I think, as well. Anything you want to add, Sheila? Sorry, you'd have to unmute.
The old unmute. Yes, well, I know he sort of still does quite a lot of talks, you know, and so he's pretty on the ball with what's going on. So I think he might, you know, people might get some help from him.
That's very helpful.
I think he's on some committees still in the European Parliament as well. So it may not be sort of specifically legal side, but I'm sure if EU citizens were having problems, they'd help if at all
Right.
possible.
Thank you, Sheila. That's very helpful. At least there's a name we all know.
And also, I think a lot of because the Euro cafes, you know, are held quite regularly now. I think if
That's a good idea.
EU people can go along, and often, you know, members of the group are sort of perhaps have legal knowledge, or would know where to send people to if they needed specific help.
Okay, anyone else got any information or comments they want to make in their closing minutes?
I do, if you can stand it, I do.
Go on, Martin, go for it.
Can I just interrupt?
Go, no, the speaker wants to interrupt. Go for
it. Quite right.
Speaker privileges. Just to note that some of the suggestions have been made in the chat. So David has noted that the 3 million, an organisation that supports EU nationals in the UK,
yes.
And Aoife has pointed out she's given the link to the list of Home Office funded organisations that I mentioned, and I have remembered that the other organisation that I was thinking of, it's a law firm called Seraphus, that again has an online portal for seeking advice and support specifically for EU nationals. I'm just looking at what the comment at the bottom is.
Yes, you have.
I can stick the IMA's URL in there.
Thank you.
Which has the contact details on, but also has a sort of a portal for reporting problems. Now, the IMA themselves they're very clear, they don't help with individual problems.
Yes.
They are there to pick up on systemic issues and
yes.
to, you know, try and solve them at a systemic level.
Thank you. I see that's come up. We'll copy that. Thank you. I think we're nearly there. Is your point burning, Martin?
I put it on the chat. It's just it's a rider to the point that was made about the 3 million. I was just saying, do you also have in limbo maybe a source of collective wisdom about the kind of things that people have you come across those, I take it, Charlotte? Yeah.
Right. Okay. Anyone else want to say any final thing? And we'll just go back to Charlotte then to wind up her very helpful. And I think I'm stressing, from my point of view, I haven't had any intelligent questions because this is quite clever for me, and I'm really going to watch it again and get my head around it. But I never realized it was so murky and such a quagmire. I really didn't. I knew, you read bits, but no, to hear an expert say how grim it all is, my heart goes out to the poor people. Okay, Charlotte, over to you then and out then, please.
Oh, well, thank you very much. And anyone who wants to ask me any further details about some of the stuff that we've been working on, do get in touch. Or if you know of anyone who would benefit from, the stuff that we do, again, point them in our direction. In fact, I'll stick the URL to our project on the chat as well.
Thanks very much.
Yeah, in short.
Oh, thank you very much.
Great.
Great.